Welcome to the Personnel Data webinar with the Data Practices Office. Today is part 2 of our 4-part series on sharing personnel data. So thank you so much for joining us today. The Data Practices Office is a small office in the Department of Administration, and we are a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions about those laws from both members of the public and government. So if you have questions about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions, and we provide legislative assistance and training. The PowerPoint that I'm using today is posted on our website, so if you aren't able to download a copy today, it is on the page where you registered, so you can go and visit that right now. We also do record our webinars and post them on the Data Practices Office YouTube page. So if you miss part of today's webinar, if you want to go back, watch a different one, you can find all of those on our YouTube page. If you would like to download a copy of the PowerPoint right now, I am going to share a file for you to download and save to your computer. So please bear with me for a moment while I navigate WebEx and do just that. Okay, you should see a pop-up window to download the file now, but some versions of WebEx, this just doesn't work. So if it's not working for you, no worries. Again, you can visit the webinar page on our site where you registered, scroll down, look for the personnel webinar PowerPoints, and you can download the same PowerPoint right now. Okay. Here is a schedule for today's webinar. As noted, we will leave some time for a Q&A session at the end of today's webinar, so you can feel free to send in your questions as you think of them using that Q&A panel on your screen. Just make sure if you do that to select all panelists when you send in your questions so that we can all be sure to see them so we don't miss them. And you can start sending them now, or you can wait until the end of the presentation. We'll definitely have time there too. All right. As I mentioned, today's webinar is the second of 4 webinars focused on government personnel data. We will host the next 2 webinars in October, so you can register for those webinars on our website, on the webinars page. And again, if you miss a webinar, one of these webinars, or just want to watch them again, they will all be recorded and posted on our YouTube page. And the first webinar in this series on section 13.43 basics is already available on our YouTube page right now for viewing. So in that last webinar, my colleague Casey covered the basics of government personnel data. So I am going to assume that all of you are coming into this with that base knowledge, because we're just going to jump right in to the different aspects of sharing this personnel data. Specifically today, we're going to cover various aspects of sharing personnel data that include tenancy warnings, informed consent, social security number collection, unions, sharing with unions, law enforcement, and other 13.43 sharing provisions. So in future webinars, we do plan on discussing discipline and complaint data. So for the Q&A section today, if you have questions about those topics, we'll probably hold off on answering them, but if you do ask them, we may try to incorporate them into another webinar later in the series. But of course, if you have questions that can't wait, you can always feel free to call or email us, and we'll be happy to offer information and guidance. All right, let's get started. So first, a reminder that public data may be provided to any person or entity for any reason. So if you want to share public personnel data or have a request for public personnel data, you can just go ahead and share that data. But as we discussed last time, most personnel data you maintain are likely going to be classified as private, right? And private personnel data may only be shared in certain instances. So first, you can always share private personnel data internally in your entity if someone has a work assignment requiring access to the data. Next, anyone that's authorized by statute or federal law, state or federal law, may also access private personnel data. So if there's a statute allowing you to share or requiring you to share, that's how that would travel. And I'm going to flag some statutes related to sharing personnel data later in this webinar. If the data are classified as private, and they likely are, right, since personnel data are private, if not public, any entities or individuals given access by the data subject with informed consent can also access private personnel data. And I will also talk about informed consent later. But regardless of how you can share the data, your own Tennyson warnings may limit your ability to use private or confidential data in different ways. So let's discuss right now Tennyson warnings in greater detail and what you do if you find yourself limited by your own Tennyson warning in practice. So as we discussed in our last webinar, Subdivision 4 of Minnesota Statutes 13.43 reverses that general public presumption in the Data Practices Act, and it states that all personnel data are private, except for the data that are specifically classified as public by the legislature. And those public data, again, can be found in Subdivision 2 of Minnesota Statutes 13.43 and the public personnel data on applicants that are listed in Subdivision 3. But as a result, much of the data that government entities collect from its employees are going to be private. And when a government entity collects private or confidential data from an individual about that individual, the government entity must provide that individual a Tennyson warning. So Tennyson warnings will vary depending on what data the government entity is collecting and what it's going to use it for. So there's not a one-size-fits-all Tennyson warning to cover all situations. But some entities might have a specific Tennyson warning ready for certain types of data collection. Maybe you have a photo collection Tennyson warning or a new employee data Tennyson warning. That's possible. But regardless, all Tennyson warnings must include the 4 items that are listed here in the bullet points. So they must first state the purpose and the intended use of data. So this is important because the entity's use of the data is going to be limited to what is listed in this Tennyson warning. So you want to make sure that's accurate. The warning must also inform the individual whether they may refuse or are legally required to provide that data. It must explain the known consequences of supplying or refusing to supply that data, and it must identify the other persons or entities with statutory authority to access the data. So Tennyson warnings can be provided, these warnings can be provided verbally or in writing, but regardless of the method you'd use, we highly encourage documenting that the Tennyson warning was provided and what it said in the event that, the sufficiency of the Tennyson warning is challenged down the road, or if an individual asserts that the private or confidential data are being used for a purpose that was not provided in the Tennyson warning. If you have all this documented, it's much easier, right, to point back and show that what was covered in the Tennyson warning. So some entities accomplish this by requiring signatures in writing or on certain Tennyson warning notices. They might have like scripts to use during intake procedures and then a checkbox or something else to document to indicate when this warning was provided to the data subject. So how you do that is, ultimately up to you. But again, we do encourage you to document in some way so that of what was provided and when, so you can always refer back to that. Okay, so we're just going to work through a couple simple examples to talk more about Tennyson warnings. So for the first example, if a government employee here at the city of Medium Lake asks the employee Louise for his home phone number, does the city need to provide a Tennyson warning? So here, yes, the government would be collecting private data about its employee, an individual, directly from that individual. So the Tennyson warning would need to be provided, and it would need to state what the purpose is for collecting the phone number, whether he can refuse, the consequences of providing the phone number, and who will have access to it. That's because these personal home phone numbers are not classified as public, again, under section 13.43. So that Tennyson warning is required. Okay, next question. So the city asks Louise for information on what honors and awards he has received. Does the city need to provide him with a Tennyson warning? So probably not. So in this situation, we're kind of reviewing the private and the public data, right, in section 13.43. So as we mentioned in our previous webinar, honors and awards received are listed as public data elements on employees in Minnesota Statutes 13.43, specifically subdivision 2A7. So because it's public, you don't need a Tennyson warning. Tennyson warnings are only required when collecting private or confidential information from an individual that is about that individual. However, here's an example. Some employees do decide to provide what we call reverse tennyson warnings, which really are just letting people know that the data they're going to provide to you are going to be classified as public. You're not required to provide these. The government doesn't need to give that warning or notice when collecting public data, but depending on the situation, you may decide to do so and think it might be helpful. So that is a possibility. Okay, example 3. So the city received Louise's home phone number. Again, that home phone number is private personnel data on Louise, since that's not explicitly classified as public in section 13.43. And this is why the city provided that Tennyson warning, right, in the previous question. But now that the city has this number, can they share it with his supervisor? So let's say in this scenario, HR collected the number as part of its onboarding process and now wants to pass it along to his supervisor in case she needs to reach him outside of business hours, right? So can HR share that private personnel data? So whether or not you can share internally with the supervisor depends on a couple of things. So first, is there a work assignment to access the data? I think you can argue there is here, but the responsible authority would have to make this determination. But it does seem reasonable, right, that a supervisor would need the contact information for their employees, excuse me. But then there's the second question. What did you say in the Tennyson warning that you provided to Louise when you collected the data? So Tennyson warnings require that you state the purpose and the intended use of this data. And if this use falls outside what was described in the Tennyson warning, you do not have authority to use the data for this purpose. So if your Tennyson warning does state that the number can be used for this purpose and there's a work assignment, you can definitely go ahead and share. And this example is just one illustration, right, to highlight that it's important to craft your Tennyson warnings carefully. This is because Minnesota statute section 13.05 subdivision 4 states that government entities are limited by their own Tennyson warnings. So think about why you need the data, how you would like to use it, and what authority you have to share with others. All of that should be addressed in the Tennyson warning so the individual subject to the data can make that informed decision, right, as to whether to release the data. If you begin using or sharing data in a way that is not described in this Tennyson warning, then you are opening yourself up to possible liability under Chapter 13. So that raises the question, right? What happens if a government entity already collected data for one purpose, but now wants to use it for a different purpose? So if a government entity collected private or confidential data from an individual about that individual, provided a proper Tennyson warning notice, and now has the data in its possession but wants to use it for a different purpose or share it with another entity or agency, Minnesota Statutes 13.05 subdivision 4 lays out exceptions to the general rule, 4 exceptions to the general rule, that data may only be used as stated in the Tennyson warning. So let's go through them. So first, certain data collected prior to August 1st, 1975, which has not been treated as public data, may be used for purposes other than the purpose it was originally collected if those purposes are specifically approved by the Commissioner of Administration as necessary for the public health, safety, or welfare. So if you need to use some older data that you have collected prior to August 1st, 1975, this may be applicable. Number 2, private or confidential data may be shared to those specifically authorized by a new state, local, or federal law that are enacted or promulgated after the government entity collected the data. So this section allows for new sharing, right, in situations where the statutory authority to share couldn't have been included in your Tennyson warning at the time of the collection because that law didn't exist. It had not been enacted at that time. So that is another exception to this rule. So number 3, private or confidential data may also be used and disseminated to an individual or entity when the responsible authority maintaining the data requested approval from the Commissioner of Administration for a new or different use or sharing, and the Commissioner approved the use or sharing as necessary to carry out a function assigned by law. And the final exception is to obtain informed consent. So let's talk about informed consent a little further right now. Okay, so a government entity collected private data from an individual, but now the entity wants to use the data it collected for a new purpose, right? Or share it with a new person or a new entity. And this is where informed consent comes in if none of the other 13.05 exceptions on the previous slide come into play. Again, a Tennyson warning is generally provided prior to government collecting information, so individuals can decide whether or not to provide the data, and then informed consent is obtained once the entity already has the data. That's sort of the distinction. So informed consent is one of the most common methods we see entities using for their various data sharing or new use needs. So government also uses informed consent if an individual asks, like goes to the government entity to release their private data to another person or entity who may be requesting data on his or her behalf. So there are really these two ways that informed consent comes up for entities. Regardless, for both ways, the requirements for informed consent are outlined in Minnesota Rule 1205.1400, although honestly that rule mainly focuses on informed consent in the context of government wanting to share the data rather than in situations where the data subject is initiating the sharing. But the main thing for both is to remember that informed consent must be in writing and cannot be coerced. If the government is requesting the release or new use, then it has to explain why that is necessary and any known consequences. And then if the data subject is a minor, a parent or guardian may need to sign as well, depending on the situation. So we do have some sample informed consent forms on our website that you can take a look at. Under our data practices page, if you go to warning and notices, you'll see a page we've created for, for breaches, Tennyson warnings, but also for informed consent. So if you click on the informed consent and scroll to the bottom of the page, you'll find different examples for situations where the data subject requests is release, the government requests is release, or the government requests a new use of the data. So you can check those out. Feel free to download, edit, and use any of those samples that you find helpful that are on our website. Okay, so with all this talk of Tennyson warnings, I do want to talk about Social Security numbers, which I'm guessing many of you are collecting when you obtain personnel data. So when collecting Social Security numbers, government entities have additional requirements to consider in addition to your normal Tennyson warning requirements. So specifically, government entities need to consider requirements in the Federal Privacy Act of 1974, as well as the Data Practices Act, sections 13.355 and 13.05 subdivision 3 when you're collecting those Social Security numbers. Okay, so first, section 13.355 in the Data Practices Act classifies whole or partial Social Security numbers as private data on individuals. So already under the Data Practices Act, since these are private data, before collecting these numbers from the individual, you'll need to provide a Tennyson warning. But in addition to the Tennyson warning requirements we already discussed, you'll have to take into consideration federal requirements as laid out in the Privacy Act of 1974. So under that law, when a government entity collects the Social Security number, it must provide a notice stating whether providing the number is mandatory or voluntary, by what statute or other authority the entity is relying on to collect the number, and how the entity will use it. Individuals are not required to provide a Social Security number unless there's a federal authority to collect it. And also, Minnesota Statutes 13.05 subdivision 3 limits the government's ability to collect and store all data on individuals that are, unless they're necessary for the administration and management of programs that are specifically authorized by law. So if this collection of Social Security number isn't necessary for the administration or management of the program, you should just not be collecting it at all. And this goes for all government data, really, but it's especially important to call out, I think, for Social Security numbers, since you especially don't want to be maintaining these if not necessary, because that can create a lot of security concerns. Additionally, the Federal Privacy Act of 1974 states that entities cannot deny an individual access to programs or benefits just because they refuse to supply a Social Security number. So the main takeaway here really is to make sure you aren't automatically asking for Social Security numbers and that you're only collecting Social Security numbers with explicit authority in federal law or out of necessity for your administration or management of a program authorized by law. If you do need to collect those numbers, just make sure you're providing a proper Tennyson warning that conforms to the federal collection requirements as well. Okay. So we've chatted about how your sharing of private personnel data may be limited by your Tennyson warnings. We've talked about how you can share this private data via informed consent and discuss considerations for collecting Social Security numbers as well. Now I want to talk about all the other sharing of personnel data, which happens via statutory authority, meaning if you don't have informed consent from the individual subject of data and the sharing you need or you want to do is not internal to your government entity with the work assignment, you need to point to a state or federal law that permits or requires you to share the data. So you need a statute. I'll talk about some of the sharing statutes we see most often now, but with a big caveat that there may be other provisions in law allowing you to share your data. It just depends on your entity and the specific subject matter. So the first statutory sharing I'll highlight is with unions. So the language around sharing with labor organizations was updated the past few legislative sessions, and we've understandably, right, received a number of questions about sharing. So the sharing requirements I'm going to discuss may sound very different from what you were trained on, even if it was just a couple years ago. So first, under Minnesota Statute Section 13.43, Subdivision 6, government entities are required to share data with unions in order for the union to conduct elections, to investigate and process grievances, and to implement Chapters 179 and 179A, which are the Minnesota Labor Relations Act and the Public Employment Labor Relations Act. So previously, before these changes, the sharing was permissive, but now it is required. Additionally, entities were previously not clear on whether they could share data classified as not public. It wasn't explicit in this section, but language was added to clarify that these data must be shared regardless of the classification. So the data must be shared regardless of the classification, although this section does clarify that Social Security numbers specifically are not necessary to implement Chapters 179 or 179A. So those numbers would not be provided to the union. But for everything else, if a union representative requests data under this provision for one of the reasons listed, a government entity is required to share those data regardless of the classification. And additionally, entities must share personnel data with labor organizations, the Public Employment Relations Board, and the Bureau of Mediation Services when sharing is ordered or authorized by the Commissioner of BMS or the Public Employment Relations Board. So this is another pathway to access for those labor organizations, and then it is authorized sharing to those government entities as well. Just a note that this provision also clarifies that the remedies under the Data Practices Act do not apply to unions. So once a union properly receives data from a government entity, the union is not subject to the remedies of the Data Practices Act if they disseminate this data. However, other remedies may apply to the union. So specifically, Minnesota Statute Section 325E.61 is called out in Subdivision 6, and that creates liabilities for businesses that maintain personal information when the information is breached. Okay, more statutory sharing provisions, these ones specific to law enforcement. So there are also statutory provisions, right, that allow sharing with law enforcement in these certain situations. So they include protecting an employee from self-harm, protecting another person from an employee, for background investigations to either the post board or to law enforcement, for reporting a crime or alleged crime committed by an employee, for assisting law enforcement with investigating a crime or alleged crime committed by the employee. So the specific subdivisions in Minnesota Statutes 13.43 that allow these sharing are cited on this slide for your review. So if you need to share not public personnel data with law enforcement, you do have statutory authorization to share in these instances listed here. Okay. There are a few other miscellaneous sharing provisions I want to highlight. Again, please remember this isn't an exhaustive list, just some of the more commonly used provisions that our office sees. So private personnel data must be shared with DEED for the administration of unemployment benefits. Schools must provide data on employee perpetrators of student maltreatment to the Department of Education upon request. Schools must share private personnel data on employees when requested by another school if the subject of the data was an employee who committed an act of violence toward or sexual contact with a student, and that individual data subject either resigned after an investigation affirmed the acts or resigns while the charge is still pending and was given notice that resignation would result in disclosure of these records. So if you are with the school district, you might want to watch out for that sharing authority. Personal home contact information may be used and shared with another government entity in the case of an emergency. for continuity of operations purposes. That's in subdivision 17. And then private personnel data on state employees must be disclosed to the Department of Administration for workers' compensation. So that's just some of those sharing provisions. So when one government entity shares data with another government entity, we like to call the data traveling data. So the provision that we're referring to when we discuss traveling data is Minnesota Statutes 13.03 subdivision 4. So last year we hosted a whole webinar discussing the different types of traveling data and how sharing data may or may not impact its classification. So if you want to check that out, I do encourage you to check it out. That webinar is on our YouTube page and the link is right here in your slides. But just quickly, I do want to know, so this statute discusses the classification of data at the receiving government entity when government disseminates data. So if the receiving government entity does not have its own classification for the data it received, the personnel data it received, then the classification at the originating entity continues to protect the data. So it would be 1343 data. So that data have the same classification at the receiving entity as they do at the entity that provided it to them. But if the receiving entity has its own specific statute, its own classification that is applicable to its own data, then those data are classified pursuant to their law at the receiving entity. So this can lead to a situation where the same personnel data is being held by two different government entities, but it might have two different classifications because the classification at the originating entity, the entity that shared it, is different than at the entity that received the data. So let's talk about that. So I will highlight this advisory opinion 1911-19011. Here, a city asked about the classification of data that their police department collected from a school district pursuant to a search warrant. It was part of a criminal investigation. So the school district argued that the data were private personnel data and that it retained that private personnel data classification in the hands of the city police department. But in this advisory opinion, the commissioner concluded that the data had traveled from the school district to the city. And because the city police department has a specific statute applicable to its data, it changed its classification pursuant to Minnesota Statutes 13.03 subdivision 4A. That's that traveling data provision. So at the police department, the data are considered law enforcement data, and those are classified by Minnesota Statutes section 13.82. So under that statute, while the investigation is active, the data would be classified likely as confidential, active investigative data. But when the investigation becomes inactive, 13.82 dictates, that the inactive investigative data become public, subject to a couple protections. So this results in data potentially having different classifications, again, depending on what entity is maintaining it and for what purpose. Different statutes are going to apply. Because here in this example, the data at the school district is still private personnel data under section 13.43, but the data at the police department are now law enforcement data under section 13.82 and will eventually become public when inactive. So again, this opinion demonstrates how private personnel data might become confidential or public or something else at a receiving government entity when the data are shared. So if you have questions, you can check that out or reach out and chat with us. Okay, so that is all the slides I have for you on sharing personnel data. So we are going to open up the rest of the time for questions in just a moment. It's a little bit of housekeeping. While we're answering questions, I will open up a poll so you can provide feedback on today's webinar or give suggestions for future webinars. We do appreciate all of your feedback to help make these webinars helpful for you. So before you log off, if you can make sure to fill that out, we would really appreciate it. You'll also notice our contact info is here, so if you have to run out today or questions pop up later, please feel free to reach out. We're always happy to discuss any questions that pop up. Our YouTube is there again. All of our trainings or webinars are recorded and posted on our YouTube page. And if you want to find out about upcoming trainings or workshops, please subscribe to our newsletter. If you haven't already done so, a link is right there. Okay, so I am going to share a poll in just a moment, and you may hear some silence as myself and my colleagues are going through the questions and preparing answers. So thanks so much.
Okay, I'm happy to hop in here and answer some questions as we're getting the poll up. And just as a note, it does look like we have some questions in here about data sharing generally, rather than in the context of 13.43 and employee data. And so I should just note that, everything that we're talking about today when it comes to sharing data is really in the context of personnel data. There may be, in fact, there are a lot of other statutory sections that authorize disclosure of not public data or sharing data in certain situations involving all sorts of different contexts. So if we don't get to one of your questions that's just about sharing, we will follow up with you and see if we can offer some clearer guidance there. And so, so just as a broad kind of answer to this first one here, can you use data such as name, address, and date of birth in order to seek written informed consent for a new use? For example, we want consent for a new project from anyone over a certain age and have DOB info. We can send written informed consent to the names and addresses of those with a date of birth after a certain date using the data to send requests for new use of the data. And so again, this may sound like maybe a sharing for programs that are outside of the personnel aspect. And so if that's the case, certainly you'll want to take a look for the classification of the data first. If it's public data, that those data can be used for any reason. And so, if you have somebody's date of birth and it's just simply public for whatever reason, then you can use that data however you see fit. If it's in the employment context here, an employee's home address and date of birth are certainly private data. And so you'll want to go back and take a look at your Tennyson warning to see how you described how you might use that data. Tennyson warnings don't necessarily need to have bullet point lists to say, hey, we're going to use the date of birth to contact you in this particular scenario. Usually they're a little bit broader than that. And so if it's, something to the extent that, we're using this personnel data to contact you, I think probably there's some reasonable wiggle room there that you could probably use date of birth to identify certain individuals and then seek informed consent from them. But again, it all goes back to the language of the Tennyson warning. If you have specific questions about your Tennyson warning, I certainly think that's a good question to raise with your legal counsel or the attorney for your government entity, and they can help you think through whether or not that's an appropriate use of the private data you've collected based on the Tennyson warning that's been previously provided. Okay, next question that we have here is relating to that data sharing with unions or union representatives. And so this is 1343, I think subdivision 6 here. Do we read the changes in subdivision 6 as meaning that even confidential data under 13.39, so that's the civil investigative data section, must be provided to the union? And so, yeah, civil investigative data. I think, yes, you still are obligated to provide data, personnel data that are maybe pulled into that 1339 section in response to a request from the union. That language in 1343 subdivision 6 A specifically says, notwithstanding classification by any other provision of this chapter, upon request from an exclusive representative, personnel data must be disseminated. I think that notwithstanding language was actually added the following legislative session after the subdivision 6 changes actually went into place. And for that specific 1339 reason, that I think some union folks were running into some barriers to getting personnel data because government entities were designating it as civil investigative data under section 13.39. And so the legislature made additional changes to add that notwithstanding language. So I don't think government entities can use section 13.39 to withhold personnel data from union representatives upon request. And then just the follow-up question to that, how do you handle if the union requests data and the entity does not think the data is necessary for the purposes stated in subdivision 6? Yeah, that's a good question. It's probably going to be a conversation with the union and maybe a little bit of negotiating there. It does say under subdivision 6 that the personnel data must be disseminated to the extent necessary to conduct elections, investigate and process grievances, and implement the provisions of chapters 179 and 179A. And so if there's a request that falls outside of that, then yeah, I don't think there's the obligation to disclose personnel data. However, if the request reasonably falls within one of those categories of data, there is that obligation to provide personnel data, whether public or private, or other personnel data that may have been scooped up under other sections. I should also note that part of the concern, I think, when this legislation went into place was sharing and whether or not a government entity would be liable if those data were disclosed. There is some language in subdivision 6 that basically says, hey, an employer who disseminates personnel data under subdivision 6 is not liable under section 13.08 for those various remedies or penalties. So that is, I think, the balance that the legislature was aiming for there, that certainly recognizing unions get a lot of personnel data in that context, and then also removing any sort of liability for a government entity to meet those dissemination requirements under subdivision 6.
Thanks, Casey. I can hop in with the next one. So first, I did see a few questions, individuals who weren't able to see my slides as I was presenting. So I'm sorry to hear that. I will absolutely blame WebEx. So hopefully we're able to resolve that. But if you weren't able to see the slides, again, if you visit our website, the webinars page where you registered, the slides are available there to download. So everything I was talking about and referring to is on those slides. And a related question for those of you joining a little bit late, when will this be added to YouTube? Very soon, hopefully, within 1 or 2 days, we'll have this up on YouTube with the slides so you can see it all together, and hopefully that will be helpful. So just some housekeeping questions there. But I can answer another question that came in. So let me just mark it as answered verbally, because then I think you can all see it. So the question is, former employee requesting all emails that contain his name. So they are the subject of the data, but no longer employed, so not privy to private or confidential government data. Do we have to provide a redacted copy of an email if it contains CGIS information, or can we just exclude the whole email? So when it comes to kind of approaching these sorts of requests from employees, if the employee is asking for all data where they are the data subject, I think Casey chatted a little bit about this last time, the mention of an employee's name doesn't necessarily make them the data subject. And because they're not the data subject, they wouldn't be entitled to any private data that's not about them. They're entitled to any private data that's about them, but if they're not entitled to any private or confidential data that's not about them. So for this particular question, this employee asked for data that has their name. If you have an email that has all this private data on someone else, or even confidential data on someone else, and the employee's name is on it, the employee's name may be incidental to the data, and so would probably not be provided in response. You would always need to cite the statutory section that you're relying on to withhold that data, but I don't think that just the existence of their name makes it data about themselves that they're entitled to if it's private data. So that is something to consider. Whether or not to provide a fully redacted copy versus withholding it entirely, I think is going to be a determination for you and how you fill and redact the data. But I don't think that they have access right to that data when it's an incidental mention of their name. So hopefully that's helpful. And that's just from the definition of individual in the Data Practices Act in section 13.02.
Okay, another question that we have here regarding the school and law enforcement example. Once the school's private data travels to law enforcement, so the private personnel data travels to law enforcement, are there regulations or obligations the law enforcement has to follow as far as private? Great question. And so in that situation where the data travel from the school about the employee to the law enforcement agency, those data would fall under 13.82, which is the law enforcement data section of the Data Practices Act. And so, some of those data, while the investigation is active, would certainly be classified as confidential, active criminal investigative data. Other data might just be public under subdivisions 2, 3, and 6 of 1382, which govern arrest data, request for service data, and response or incident data. However, once the investigation becomes inactive, because the law enforcement agency decides not to pursue the case, or maybe the person's convicted and their appeals rights are exhausted, then all of that data is going to become public. And so, any sort of private personnel data that are heading from the school, for example, or any other government entity over to a law enforcement agency, those data are going to become public at some point. And so there are some other exceptions that protect the identities of certain individuals under Subdivision 7 and 1382. But yeah, generally, any data, private personnel data that's sent over to the law enforcement agency will become public at some point in the future.
Okay, we have a, oh, sorry, Grace, you can go ahead.
Oh, okay. This question says 1343 allows a government agency to disseminate private personnel data to a law enforcement agency under subdivision 15 for the purpose of assisting law enforcement in the investigation of a crime committed or allegedly committed by an employee. If a government employee is being prosecuted for the commission of the crime, is the prosecuting agency, such as the county attorney's office, considered a law enforcement agency? Here, I would say that the prosecuting agency probably is not considered a law enforcement agency for the purpose of this sharing. The sharing is really limited to reporting a crime or alleged crime or assisting law enforcement with the investigation of the crime. By the time it gets to the prosecuting agency, the law enforcement investigation is over at that point. They've done their investigation and they sent it to the prosecutor to either charge it or not charge it. So I don't really think there's a clear sharing there, and the prosecutor could get a court order if they do need private data from your agency.
Okay, so we have another union question, understandably. So let me mark it as answered. There we go. I have a question related to the sharing of personnel data to labor unions for purposes of investigating or processing grievances under 13.43 subdivision 6. Does the data that must be disseminated include another employee's private personnel data? For instance, does the labor union get a witness's or a complainant's private personnel data as well, or should other employees' private personnel data be redacted? It's a good question. Casey was chatting about this. The sharing authority in subdivision 6 is very broad, and it's regardless of classification, right? So the union does have an access pathway here to not public data on employees for investigating or processing grievances, or again, for purposes of 179 or 179A. And so if the union is making the case that they need that private personnel data in order to investigate or process grievances, I think there's an argument here that they're entitled to that data under the subdivision 6 language. It is a pretty broad sharing authority. If you get those sorts of requests, you might just want to have a conversation with the labor organization and see what data specifically they need for that, the processing grievances, because they may not necessarily, and so then you can just go ahead and protect it so that you're not unnecessarily disseminating not public data, right? I could have that conversation with them, but I do think they have access right here if it's needed for those purposes that are listed in subdivision 6.
Okay, just to follow up, a lot of questions about that union sharing, which is understandable. It's pretty new, and so same question regarding sharing with unions. But what if the data to be protected are security information, designated as security information under 1337? For context, 1337 allows government entities to designate certain data as security information if the disclosure would lead to some sort of harm, the disclosure of information. And so there's all of that defined under 1337 subdivision, I think 1A. And so, yeah, it's a great question. I don't think 1337 would be a barrier to the to union officials obtaining, or union representatives obtaining data. Primarily due to that notwithstanding language. Once again, it doesn't make an exception for 1339 or 1337. That it's notwithstanding basically across the board. So I don't think a government entity can designate data as security information as a way to say we don't have to provide data under to a union representative under 1343 subdivision 6. Again, as Ellen mentioned, I think if there are concerns on this front, having that conversation with the union representative and speaking with them about what's necessary and what's needed, I think that's the best approach. But yeah, that notwithstanding language doesn't create any exceptions. And so basically, if it's personnel data, I think the union representatives can get it under 1343 subdivision 6, so long as it's related to one of those categories of necessity.
Thank you, everyone. We had some great questions, and we had many great questions that we were not able to answer in the allotted time. So if that is you, I do apologize, and we will be following up with you directly to discuss your question and provide some information that's hopefully helpful. So please watch out for that. We are at time, so I appreciate everyone being here today. I did see a question about the CLE credits. I will chat about that in just a second when I stop recording. Again, you are more than welcome to send your questions to us at any time. We encourage you to fill out the poll, and thank you so much for your time today.